kindly comes to the reasoned order of 18th January 2018, which is at page 115, volume 1. My lord has found 115.
No, yes.
May I place beginning from this is with reference, my lord?
Hmm.
This is with reference to your application regarding grant of pensionary benefits and the order issued by the Honorable CAT Kolkata bench, which was disposed of on 13 November 2017. You had proceeded on leave with effect from 29 December 1991 and did not join further at this institute. The ICAR, on examining your matter, has decided that you be deemed to have resigned from the council service with the effect from the date you proceeded on leave, which is 29 December. Now the important part, my lord. It is revealed from your service record that you were in service from 28 September 1976 to 28 December 1991, which is 15 years, 3 months, and 1 day. And your qualifying service is 11 years, 11 years, 11 months, and 13 days, deducting the non-qualifying service. Then they go on to quote Rule 26, saying since you have been deemed to have resigned, you are not entitled to your past service. Nonetheless, this perhaps is an admission that I have minimum qualifying service. 11 years, 11 months, and 13 days. My lord, so the argument here is if the power to invoke the provision under Rule 12 did not exist at the relevant time, the recourse that could be had by the ICAR was to initiate a disciplinary proceeding, which was never initiated, although they had intended to. They had intended to issue such a proceeding.
Intended to issue, where do you get that?
Yes, my lord. Gives me a moment.
Yes.
Yes, page 187, my lord. Volume 2. My lord will find it in volume 2. Kindly comes to the last paragraph, as may kindly be seen. My lord has found, my lords.
Yes.
As may kindly be seen from letter number such and such dated 30th January 2002, received from the officer in charge, Cecil Station, Bamra, Orissa, that is the place of posting Dr. Das attended his duties last on 20th December 91, and since then he is absenting. The matter of his long absence from duties till date was consulted with Sri Shubir Kumar Bhattacharya, authorized pleader of this institute. Sri Bhattacharya, while his notice dated 21st February 2002 was kindly opined that a notice may be served to the officer why he will not be dismissed from service with immediate effect for his unauthorized absence. So their internal correspondence indicates that they could have served a notice upon me, but they did not. Ultimately, they did not. And kindly take
But
rule.
did you get this? How did you get? How did you get this? They disclosed this before the writ court, or
No,
this is
it
the
was
writ court?
part of the pleadings in the original
Very
application.
yes.
Kindly sees Rule 25 of CCS pension rules. Kindly sees Rule 25 right at the beginning. Rule 25, Sub-Rule 2, my lord. Willful absence from duty after the expiry of leave renders a government servant liable to disciplinary action. So, in the absence of power to invoke Rule 12,
Yes.
the recourse is perhaps provided under Rule 26. Unauthorized absence, disciplinary action should have followed. willful absence.
Rule 25.
Rule 25, I'm sorry, Rule 25, sub rule 2.
Yes.
But this did not happen. There was no charge sheet, no inquiry, nothing. The tribunal, my lord, proceeded to decide the issue against the writ petitioner on the ground that Rule 12 was rightly invoked. But this issue, my lord, the amendment having been come into effect.
This amendment to the notice of the court, this
No,
point.
this was not brought to the notice, or perhaps not brought to the notice of the court. But there was.
But it would vitiate the inherent authority to employ that rule. Because it's a legal point, then, pure question. Could have taken for the first time.
If they have chosen to use the words deemed resignation, my lord, it is a power provided under the statute, and
That
it
is what
cannot
we are
be.
saying. You can
Yes.
take that before the writ court first time also.
Yes, if a
Yeah.
point of law, because it is, yes.
Because it's a lack of inherent jurisdiction to invoke this rule.
Yes.
If it was not the statutory power, as you say, the power was not derived by them
The
before.
power was not even there they could not have invoked such a power for deemed resignation.
All right.
Now, my lord,
Take it.
now the writ petitioner, my lord, had raised these issues. They may take this point that you did not raise these issues before the tribunal. You are raising these issues now, as my lord has just pointed out, that these issues can, even if they were not raised before the tribunal, they could well be raised even in this writ petition.
None of these issues are raised.
No, I have raised these issues. I have also questioned the jurisdiction of the officer who has issued the order. All these things were raised.
Only Rule 12 was not raised. That it
Yes,
came into force
expressly
after.
not raised. Yes.
That was it. But the others you have taken,
Yes,
this
yes.
precedent not being the comprehensive.
Yes.
These you have taken.
Yes. That will be evident from the tribunal's order itself.
Disciplinary action point also you took.
Yes. All these points were taken.
Correct.
Now the tribunal proceeded on the, as when it kindly comes to the tribunal judgment,
Yes.
volume 2, last page.
One, certificate copies.
Kindly comes to my lord, internal page 7 of the judgment, the impugned order. Last paragraph, learned counsel for the respondents.
Internal page, where do you find the internal page?
It's possibly because of the stitching, my lord.
Yes.
Yes.
Ah, it's a 7, yes.
The kindly comes to the last paragraph. Learned counsel for the
Yes.
respondents. That they had raised this issue that Rule 12 allows us the power to to say that you have been deemed to have resigned. Now, what is the finding of the tribunal? Yes, kindly comes to page 10.
So entire pivot of the judgment of tribunal is the Rule 12.
Rule 12, that it was rightly invoked.
Because under Rule 12 they have the power.
And it kindly comes to paragraph 10, page 9,
Yes,
paragraph 10.
seen that, yes.
It is the applicant's case, here, my lord, this is how it is evident that I have taken these points. It is the applicant's case that their husband/father was not given any opportunity to explain his conduct before passing of the order of deemed resignation. This being in violation of the rules as well as principles of natural justice, order dated 23rd April, and all subsequent orders are legally unsustainable. It is also the contention of the applicants that the order was passed by an incompetent authority and does not contain reference to any rule or provision under. So, my lord, it seems I have also taken the issue of the rule. Yes. Kindly comes to paragraph 11. It is not in dispute that the husband/father of the applicants was absent from work and that he never resumed his duty thereafter. It is the applicant's argument that the employee was busy with cases in the tribunal and Honorable High Court since 1992 on service-related claims. However, it is seen from records that there was no order or direction from any court on him not to join his work, nor was he prevented in any manner from joining his duty during pendency of the cases. Moreover, all these cases were filed by him and their pendency cannot be an excuse for not reporting for duty. Therefore, after a lapse of 5 years, since he was continuously absent from work, the above quoted Rule 12 sub-rule 2 is rightly attracted. And this is where I join issue with the tribunal, because this power was absent. I don't know, prima facie on the face of it, it appears 12 years of absence, this is a grave problem. But an opportunity ought to have been given to me. At least a show cause should have been given. Now, my lord, my learned senior friend may point out that on previous occasions there were instances of unauthorized absence. My lord, but they have chosen to condone those things. They have issued minor penalties of censure. Once they have issued censure, and on the other occasion, dies none. No work, no pay, which they have excluded from my qualifying service, as was pointed out, my lord, a while ago, where it is clear that after excluding the period where no work, no pay was imposed upon me, I still have a qualifying service of 11 years, 11 months and odd. So I have that qualifying service. Now, my lord, as regards invoking this rule, it ought to have been in the statute book, which it was not. It was not at the relevant time. The other argument that can be raised is abandonment of service. You abandoned and there was no requirement for a disciplinary proceeding. My lord, over here, when this matter was last heard, my lord, before the Honorable Chief Justice, my lord had pointed out that we ought to consult the judgment delivered in D.K. Yadav's case. D.K. Yadav versus JMA Industries. My lord, here the Honorable Supreme Court has held that since any decision which leads to the termination of an employee, even if it is on the ground of unauthorized absence or abandonment of service, an opportunity must be given. That is the principle of law laid down. Kindly, I shall point out the relevant paragraph. That kindly comes to paragraph 8, 9, and 10.
Yes.
Kindly see paragraph 9 once. It is a fundamental rule of law that no decision must be taken which will affect the right of any person without first being informed of the case and giving him or her an opportunity of putting forward his or her case. An order involving civil consequences must be made consistently with the rules of natural justice. And then reliance has been placed upon Mohinder Singh Gill. Kindly comes to paragraph 11. The law must therefore be now taken to be well settled that procedure prescribed for depriving a person of livelihood must meet the challenge of Article 14. And such law would be liable to be tested on the anvil of Article 14, and procedure prescribed by statute or statutory rule or rules or orders affecting civil rights or result in civil consequences would have to answer the requirement of Article 14. So it must be right, just, and fair, and not arbitrary, fanciful, or oppressive. There can be no distinction between a quasi-judicial function and an administrative function for the principle of natural justice. So even if it is an administrative order, it must abide by the requirement of Article 14, as it is indicated here. If administrative as well as quasi-judicial. So even if we deem that this order of deemed resignation is merely an administrative order, prerogative of the employer, even then Article 14 must be met.
Yes.
And this is the proposition, my lord. Hence, the 8, 9, 10, these paragraphs are relevant to be considered, my lord. Yes, and also, my lord, once. Yes, my lord, those are my submissions.
Yes, sir. What is your?
If they say, I mean, I may be allowed an opportunity to.
Yes, yes.
Lordship, the tribunal's order, Lordship.
Yes.
Before moving this,
Take your seat, Mr. Chakravarti.
Yes.
Before moving this, Lordship, this OA application, husband of the petitioner move about 5 to 6 times, challenging the DIG non-censor. Every time he has either dismissed the application or rejected. Every time, not once. Every time, 4 5 times, I personally appear in the all the OA application, Lordship. The tribunal had dealt in the order everything, Lordship. Lordship, in the CAT, Lordship, the earlier absented, Lordship, the order of the CAT, Lordship, page same. Just now, my learned friend shows page 78. Challenge page 78, Lordship. He was absented from duty and challenge before the tribunal. Page 78, Lordship. Just my learned friends, Lordship.
Yes.
Last portion, I'm not going to entire Lordship. The last portion, Lordship, the page 84. Lordship, the OA filed. However, this his claim joined another allied department is not supported by the relevant document of such CMRI and not under control of ICR, the main organization. Hence, the period of unauthorized absence from duty by the applicant rightly treated as dies in none by the respondent and following the principle of no work, no pay as held by the apex court. This order the petitioner challenged before the Honorable High Court in the WPCT.
Yes.
WPCT was dismissed. The WPCT was dismissed. Even the then Honorable Justice Gupta has said, why not you going to join? He said, no, I will continue fighting the case. Then after again he filed case challenging the censor, deemed resignation, everything challenged. Everything, Lordship, as per the rule, Lordship, the maximum period of absence, I'm not going to deem resignation or non-resignation, Lordship, the deemed maximum period of absence 5 years. If anybody absent more than 5 years, not entitled for the pension. His pension will be forfeited. This is the rule. Even
Rule 7.
Lordship. He absent, Lordship, more than 5 years.
Please give another copy.
Lordship. This is for future clause, Lordship. He was absented more than 20 years, 10 to 20 years, 15 years. So, qualifying service is not the question. Question is, why not he joined unauthorizedly?
But
This
the
is a for future clause, Lordship.
tribunal and your client both relied on Rule 12 before the tribunal.
7, 12, Lordship. 12 and 5, 7 I have cited there, Lordship.
7 was never considered by the tribunal.
For future clause, Lordship. Sometimes, Lordship. If anybody absented more than 5 years, his pension will be forfeited. Or his husband, her husband was challenged the censor, dies in none, deemed resignation, everything before in the cat. Every time he lost the matter.
So all India services leave rules are applicable to your case.
Yes, we are central government employee, Lord, central government organization. Lord, see the order of the tribunal may see very good judgment. I think so.
Let us see that.
Lord, very good judgment because everything my tribunal, learned tribunal dealt. Lord.
Let us see that portion of the judgment.
He filed review petition, that was dismissed. OA dismissed, everything dismissed.
Just show us where this was dealt with. This.
Lordship, the order of the tribunal is annexed. Lordship, the page mark.
Where are these dealt with? These rules?
Huh?
These rules were never dealt with. The All India Services Leave Rules, 1955. Then I find any mention of it by you or by the tribunal before the tribunal.
But that portion was dealt. That 5 years, Lordship, dealt by the.
You are an autonomous body. You are controlled by the central government.
Yes, 100%.
But how do we know that these rules are applicable to you? Per se, it may not be applicable.
No. Then, Lordship, just in the morning, I will see, Lordship, one matter argue, then I will produce the central government administrative rule. Then, Lordship will clear from that the central government rule is applicable. Administrative Act notification.
No, but we don't find the mention of this rule anywhere in the tribunal's judgment. Or your reference to this?
Lordship,
you are
the tribunal is the quoted, Lordship, the order, the portion of the, where the quoted is the W.
Which
rule, Lordship?
Which page?
Granted control. Lordship, the page number not.
This rule, this 26, what is this?
Letter, Lordship, yesterday.
No, what is this? Lastly, you handed over 26?
Yesterday, forfeiture.
This is a part of which rules?
They amended, Lordship, yesterday night they handed over. I forfeiture of the.
You don't know, then why did you hand over to court?
Lordship, yesterday night I asked them, where is the provision for forfeiture? Then they sent this.
What is this a part of? We don't know.
Central government rules.
This may be anything.
Lordship, then I will ask them. Lordship,
You don't know what you are citing, and you are citing it to a court.
Lordship,
please take this back. Yesterday night they handed over. You are handing up to the court.
Lordship, the page internal page 8 of the order. Lordship may be seen. Internal page 7 of the order may be seen. Internal page order 7 of the
7. Yes, we are there.
Learned correspondent cited the CS Rule 12(1) and 2. No government servant shall be granted leave any kind for
a country. Entirely Rule 12 all through. Entirely Rule 12.
Lordship, then adjourn. I will produce the 12 Rule 12. Lordship, I will produce because I written notes of argument at 5.
You need not produce it. It's already before us. But just show us that these rules are applicable to him also. These were never relied on by any of the forums at any point of time.
Lordship, page 12, 12.
For the first time, you are relying on these rules before this court, sir.
The same, yes.
This was not relied on before the tribunal or at See, no. Neither in the notice which you issued to him, nor before the tribunal, you never relied on these rules. How do you know that these are even applicable? For the first time, you are relying. Let us see your notice, whether you have relied on this rule. Let us come back to your notice once. You see, page 115, you rely on Rule 26 of the CCS pension rules. Page 115, you rely on the CCS pension rules. And also, before the tribunal, you relied on the CCS rules, CCS CSA rules. Nowhere you have relied on these rules. How do you know that these are even applicable to you? Per se, central government rules may not be applicable to ICAR.
No. All applicable. This may
what all?
Lordship, morning.
What does this gesture mean? We don't understand.
No, Lordship, morning argue, Lordship, matter, not the matter. Whether, as per the Administrative Tribunal Acts also, Lordship, the...
Satisfy us that these rules are applicable.
Lordship, matter may, Lordship, I bring the Lordship. Yes, Lordship. I bring that rule also.
Heard learned counsel for the petitioner.
My Lord, I'm kindly has a look, my Lord, at Rule 31, my Lord. These are their bylaws. Kindly. ICAR bylaws, my Lord, Rule 31.
Exactly. Yes. Give a copy to him also. He has not been instructed by his client. You instruct him.
Rule 31.
Instruct him and say what is the law. Tell him what is the law. Please check up, Mr. Chakraborty, whether these other rules are applicable. The All India Services Leave Rules, 1955.
I shall check.
Your friend is relying on this. Je ponto bolam eta thakbe. Learned counsel for the respondent authorities, at the time of arguments, seeks to rely on Rule 7 of the All India Services within bracket leave bracket close rules, 1955, which were never relied on by the respondent authorities either in their impugned notice or before the tribunal at any point of time. Full stop. On a query of the court as to whether such rules are applicable to the service of the incumbent in respect of whom the present writ petition has been filed, learned counsel seeks accommodation to satisfy the court on such count. Full stop. At this, learned counsel for the petitioner places reliance on Rule 31 of the bylaws, bylaw 31 of the bylaws of the ICAR, under whose service the incumbent was, which stipulates that the Central Civil Services bracket classification, control and appeal bracket close rules and the Central Civil Services bracket conduct bracket close rules of the Government of India are applicable. Full stop. Next pair. Be that as it may, in order to enable learned counsel for the respondent authorities to satisfy the court on the above count, the matter is adjourned and shall next be listed on August 18, 2026.
Not August, Lordship, September 20 after 22. Lordship.
No, 18th August.
No, Lord, 18th I will out of station. 20 up to 20.
Be in station. Be in station.
Lordship.
Be in station.
No, I will out of station.
No, come back, come back.
No, from 14 to Lordship 22, I will out of Lordship.
August 25, 2026.
Yes, 25. I will.
August 25, 2026.
Okay.
Push up. প্রথমেই হার্ডিং পাঠ করি।
Yes.
Grateful.
You also check up whether anything goes against you on this. These rules are applicable. If you find anything, Mr. Chakraborty, which says that these rules apply to you, then you also point those out.
All India service rules.
All India, you have quoted it in the order.
Yes, yes.
Yes, leave rules. If you find anything goes against you, you point that out also on the next
Yes.
option. Thank you.
Well, in this matter, I am for the private respondent petition. Respondent number 8, petition.
Sorry, yes.
But in this matter,
Previous occasion, yes.
last occasion, the appellant was
Same
not
thing.
there. My lord, the order has been complied with by the department also in the memo.
This is a what order?
My lord, the impugn order challenging this appeal has been papered, that has been complied with. My lord, it is an unauthorized construction over the PWD road. The opportunity, the learned
What was the order of the learned single judge?
single judge was that
Demolition.
no, my lord, giving opportunity and of hearing of all the parties, and upon the report from the concerned BLLR,
They have participated in that.
they participated, order passed, thereafter the
You got a copy of that order?
My lord, right now I have not, my lord, it has been complied with.
Many
Also,
even
I am-
on the last
That-
occasion also they did not
yes,
appear.
my lord. I have not gone into the merit of the case of the my lord. Your lordship so desire, I can come back with the all the documents, or your
Come back with those documents and we'll, instead of dismissing for default, we'll pass a comprehensive order indicating that if he has submitted to that jurisdiction in terms of the order, then nothing remains in the appeal also. None appears for the appellants at the time of call. Full stop. This is the second such occasion. Full stop. Next para, learned counsel for the respondents. You are for the private respondent.
private respondent.
Learned counsel for the private respondent submits that the order impugned in the present appeal has since been complied with by the appellants by participating in the hearing before the authorities, which has culminated in a reasoned order. Full stop. Learned counsel for the private respondents is requested to furnish necessary documents in support of such submission. Full stop. The matter shall next be listed under the same heading on August 18, 2026.
My lord, with leave of the Mr. My lord Justice Bhattacharya, I congratulate Mr. My lord Justice Dey. This is my privilege to appear before the lordship.
My lord, I am for the appellant. My lord, subject to correction, my lord, there was no direction for preparation of paper book till date. My lord,
On the papers which are there, we can hear you. There is a stay application also that must contain the relevant.
yes, my lord, but then again, the appeal can be heard out, my lord, because my lord, what happened
We
is,
generally do that only.
my lord, what the crux of the matter is, because my lord, maybe at the end of it, I'll be praying for a bit of time because I'm preparing the compilation of judgments, because the point is very short. Whether the booksellers guild, for the purpose of holding the book fair, is amenable to writ jurisdiction.
You are the booksellers guild.
No, I am the Association of Protection of Democratic Rights, APDR.
So
we
repetition
apply-
was allowed at their behest
No, my lord, it was dismissed at I was the writ petitioner,
on the ground that it is not maintained.
not maintainable.
Private body.
Whether it's a public function. And
Interesting. Most hobby interesting. Yes, then come back on the next section.
Madam.
Learned counsel for the appellants, comma, after indicating the outlines of the case, comma, seeks an accommodation to come prepared with a compilation of judgments. So accordingly, let the matter stand adjourned till August 18, 2020.
August 18.
Come with the judgments and
I'll
the learned advocate and record for the appellants is requested, comma, in the meantime, comma, to give a fresh notice to the respondent authorities as to the pendency of this matter.
my
Give
lord,
notice.
18th.
If you can, please give a copy of this compilation or indicate the citations to them also.
To the
Respondents.
to the
So
respect.
that they can come prepared.
So they can come prepared.
You are
Fine.
appearing for the respondent. Need not move away. If you're not appearing, you are not appearing.
Well, grateful.
Yes.
Great.
Lord, I am appearing for the appellants in this matter.
Yes.
My Lord, this is, my Lord, against an order.
Chakravarti, you are soft spoken. Mike is soft spoken. We are hard of hearing. Please use the microphone so that we
My
can
Lord.
hear.
My Lord.
Yes.
My Lord, this is an order, my Lord, granting ex parte injunction at interim stage in a suit for defamation. My Lord, I am appearing for defendant number
You
one
used the
and
matter on the last occasion.
yes, my Lord.
But it was not part heard,
My Lord, it was not part heard.
thankfully.
My appeal was admitted,
Yes.
and my Lord directed, since my Lord the injunction application, my Lord, was annexed without annexures, my Lord directed me to file a supplementary affidavit. My Lord, my supplementary affidavit is ready. My Lord, may I file, my Lord? I have also served to my learned friends, my Lord.
Have served.
Yes, I have served. My Lord, question is whether, my Lord, in a suit for defamation, in an injunction application,
Was
ex
Mami
parte.
represented at any point of
Yes,
view?
my Lord.
Devnath
Mr.
Ghosh.
Devnath Ghosh was appearing.
Yes.
My Lord, the issue is that whether in a suit for defamation, in an injunction application, at the ad interim ex parte stage, my Lord, whether the order can be passed. My Lord, the bonnet.
This was the defamation in the commercial sense.
Not, my Lord, in the commercial sense. My Lord, if I may give a brief background of this matter, my Lord, I am a YouTuber. My Lord, as my Lord knows, the social, my Lord, content creator and my Lord, influencer. So, my Lord, I am that, and my Lord, I am a certified physical trainer. And my Lord, I am also a sports science nutritionist. My Lord, this is that matter.
Certain
my Lord.
products of
Yes.
you had pointed out the lacunae in those.
Yes, my Lord. My Lord,
So you have been injuncted from doing what? From publishing any defamatory material against them.
my Lord, yes, my Lord, from displaying and my Lord, from airing in the.
Say that your right of speech is freedom of speech is affected.
My Lord. And my Lord, also, my Lord, I am, my Lord, today, I have the defense of truth. In a defamation suit, my Lord, I am protected not, my Lord, only by, my Lord, freedom of speech and expression, but also, my Lord, defense of truth and fair comment. My Lord, I have in the, my Lord, in fact, the plaintiff has in the petition disclosed my reply to their, my Lord, notice, to their demand notice. In that reply, my Lord, I have, my Lord, elaborately, my Lord, stated what the facts are. My Lord, in fact, before, my Lord, making, my Lord, a video and uploading the video on YouTube, I have done 2 testing. All done by, my Lord, NABAL accredited and FSI, my Lord, approved and recognized, my Lord, agency. This is a third party, my Lord, independent lab testing which was done, and twice. My Lord, what is this product, my Lord? Let me first, my Lord, apprise, my Lord. My Lord, this is Jhandu Ashwagandha Gold Plus. My Lord, they sell, my Lord, the capsules, my Lord, which have, my Lord, they content that this has withanolides, and withanolide is, my Lord, helpful for treating insomnia for sleep deprived, my Lord, individuals, and it also enhances energy performance. So, my Lord, that's the reason they say that the capsule that they have, it contains withanolides. Now, my Lord, before doing any testing, my Lord, we receive, my Lord, complaints from, my Lord, various, my Lord, individuals from the, yes, my Lord. So from their, my Lord, requests and, my Lord, complaints, my Lord, we do the blind testing. We purchase, my Lord, these items, my Lord, this particular capsule, my Lord, box, my Lord, we have purchased from Amazon through, my Lord, an anonymous, my Lord, name. And, my Lord, we have, my Lord, recorded in the video the unboxing of that, my Lord, parcel that we purchased from Amazon. Then the sample is straight away sent to, my Lord, the testing agency. My Lord, in our case, there was an agency called Eurofin. My Lord, this Eurofin agency, they are, my Lord, NABAL accredited and FSI recognized and approved agency. So, my Lord, they first tested, my Lord, there was 2 testing done. One for to check, my Lord, the withanolide content, because that's very important in, my Lord, Ashwagandha Gold Plus. And second testing was for heavy metals. Now, my Lord, in the first test, my Lord, report, I have, my Lord, also with my representation annexed the my lord, reports. And these were before the learned trial court, my lord, at the time of, my lord, consideration of the injunction application. My lord, the first test report, my lord, it was showing 16.98 milligram per kg lead. This is a heavy metal. My lord, it should have been, as per, my lord, the permissible limit, it should have been 10 milligram per kg. My lord, so, my lord, there is, my lord, 69% alarming, my lord, high rate of, my lord, heavy metal found in this, my lord, capsule. And, my lord, these capsules are supplement, which are, my lord, taken every day, twice a day, by, my lord, individuals who purchase this, my lord, supplements. Now, my lord, this is lead. Another heavy metal was found, that is, my lord, mercury. Now, my lord, mercury was found, my lord, the content is 7.28 mg per kg. The permissible limit is 1 mg per kg. So, my lord, there is, my lord, 628% more, my lord, content of, my lord, heavy metals.
Yes.
My lord, now, my lord, this is the first report. My lord, we have done a retesting because, my lord, we know that this is Emami's product. So, my lord, we have done a retesting to be doubly sure. My lord, this retesting report was also shocking. My lord, the lead content was found, my lord, 14.52 mg per kg, which is 45% higher than the, my lord, permissible rate. And, my lord, the mercury found was 8.45 mg per kg, which is, my lord, higher than the first test reports. My lord, now, my lord, this is, my lord, 700.
This was from a different lab. The second test, the same lab.
My lord, same lab.
But
Same.
all the same, it's a NABL accredited and FSSAI.
Yes, my lord. Yes,
Correct.
my lord.
Yes.
Same sample, my lord, we have done, my lord, retesting.
Right.
So, my lord, shocking reports were found.
Yes.
And, my lord, the withanolide, for which, my lord, these supplements is mainly purchased, my lord, withanolide was found only in 0.5, my lord, mg. Withanolide. Though, my lord, it should have been in 200 to 300 dosage, my lord, it should have been there. My lord, I will show, my lord, a report of, my lord, the researchers, my lord, their report which was published in the Oxford University
It is
Press.
required to be.
My lord, if I may, my lord, show the report itself. My lord, the withanolide content, my lord, it should have been 200 to 300 mg per dosage.
Or what?
For, my lord, the withanolide in the, my lord, ashwagandha content of withanolide in ashwagandha, and it was found to be 0.50%. Now, my
There
lord,
are not content in ashwagandha.
My-
Raw ashwagandha is 200 to 300 mg.
yes, my lord,
Whereas in their product, it's 0.5.
my lord.
But they are portraying it to be a methanol product, ashwagandha.
Yes. Now, my lord,
These reports were a part of the records before this before the trial court. Oh no, it was ex parte order.
it was an ex parte order. It was an ex parte order.
So
But
can we look
these,
into these documents at this stage?
my lord, these reports, these were annexed to my
Reply to their
presentation.
notice, which was a part of this.
Of that. Yes, my lord.
Correct.
Yes, my lord. My lord, and my lord,
Notice
the-
reply দিয়েছে, সেটা annex করে। Yes.
my lord, before, my lord, uploading any video, my lord, in the YouTube platform, we always, my lord, first ask, my lord, the concerned party as to what is their remark and or comment with regard to the video. My lord, in this particular case, my lord, 24 hours time is given to them before uploading any video. My lord, in this case, we have not received any, my lord, comment or feedback or objection from Emami. 26th May, we uploaded the video. 2025, we uploaded the video. Thereafter, my lord, and my lord, one more, my lord, important aspect, in our website, my lord, we have, my lord, there is a, my lord, link that if anyone is challenging the report, every report is, my lord, uploaded in our website. There is, my lord, a link. If anyone wants to challenge my report, the report of the third-party agency, they can do so. In the present case, Emami has not challenged the report. My lord, they have, what they did, is, my lord, 17th April 2025. They issued, my lord, a letter or notice, my lord, through their advocate,
17th of
April 2025.
26th May, you said you uploaded.
2025, 26th, my lord, I stand corrected, 26 March. It will be 26 March.
17th April, they gave a notice to you.
Fine. My lord, this is a lawyer's notice that we have received.
You give a reply to that, where you annex all.
Yes, my lord. I have annexed the report once again, and I have described, my lord, I will take, my lord, through that, my lord, representation. It was
Trial court did
before the
not
trial
consider
court.
all these.
Trial court did not consider all this, my lord. And thereafter, I have in that letter, my lord, also said that I am taking down my video for the time being. Once I receive a suitable response from you, I will incorporate that in my video and re-upload, and will take necessary steps. My lord, I have, my lord, issued a letter. In that letter also, again, I have annexed the test reports. No, my lord, defense or no objection to the test reports were taken. No exception to the report also taken. My lord, they have issued a rejoinder to my reply. I have immediately also responded to the same. My lord, my query, I will show, my lord, it was very simple, that the people, the general public will be taking these supplements on daily basis. If there is heavy metal of this nature,
They should be aware of this at least.
absolutely. My lord, that is only my contention.
So you say there was truth behind you, backed up by NABEL accredited labs,
My lord,
and that you are only portraying the truth on your content,
my lord,
which the public should be aware of. You are not demeaning their product as such in any other sense,
my
but
lord,
you are just calling out the truth.
my lord. And my lord, one more aspect.
Yes.
In the YouTube video, my lord, there is in the description box, my lord, I have given a disclaimer. That disclaimer is very, my lord, clear. I will show this disclaimer also. It says that the parties have to independently do their research before taking any or being influenced by my video. They can independently do their research on this. So this disclaimer is there in the box, and when the video was, my lord, at the beginning of the video, the disclaimer was also screened. So, my lord, the disclaimer was twice there. Now, my lord, if I may take, my lord, first through, my lord, the order, impugned order first, my lord. My lord, the impugned order is dated 3rd May 2025.
My lord, may I just interrupt and say one thing? My lord, I'm led by Mr. Ghosh in this
We're in the
matter,
middle
my
of
lord.
hearing now.
If my learned friend completes the submissions, kindly
Then you
promise
start.
me to reply on the next date, my
No,
lord.
no, you start.
My lord, would kindly, my lord.
Please, Chakravarti, quickly finish. So
Fine.
that
My lord. My lord, if I may show.
no, take your time. Yes, you will get time. Yes.
My lord, 3rd May order, if I may show.
3rd May.
My lord. The case record is placed before me on strength of a put-up petition to move the application under Order 39, Rule 1 and 2, read with Section 151 CPC on behalf of the plaintiff. Learned advocate for plaintiff has moved the put-up petition to move the temporary injunction application. Please allow. Learned advocate representing plaintiff has moved the temporary injunction application filed under Order 39, Rule 1 and 2, read with Section 151 CPC, dated 2nd May 25, contending that the plaintiff petitioner is a company having goodwill and reputation and is engaged in manufacturing and marketing of health, beauty, personal care, and other allied products, and is one of the leading and fastest growing personal and healthcare businesses in India. It is contended that the petitioner commences manufacturing Ayurvedic medicine and medicinal preparations as well as cosmetic products in India in the year 1982 and having several reputed brands including
We are not responsible.
Jhandu, Navratna, Dermicul, Himani, etc. and has a portfolio of over 300 products based on Ayurvedic formulations. The petitioner launched an Ayurvedic proprietary product under the brand Jhandu Ashwagandha Gold Plus in the year 2023, which has generated substantial goodwill. But very recently, respondent number 1 has purportedly launched a video over social media on its official YouTube channel around 26 March 2025, wherein the said product of the plaintiff petitioner has been shown in a bad light, ineffective, useless, and poison in a bottle, which has been annexed with the temporary injunction application marked as Annexure C. My lord, I will show that Annexure C. My lord, this is the storyboard of the YouTube video. It is also stored in a pen drive. Respondent numbers 3 and 4 are intermediaries. My lord, this is Google and YouTube, my lord, respectively. The respondent numbers 1 and 2, these are my client, my lord, appellants, have uploaded and dispersed the impugned video over various platforms owned and controlled by respondent numbers 3 and 4. And by that impugned video, the respondent number 1 purportedly claimed that the product Jhandu Ashwagandha Gold Plus contains mercury and lead beyond permissible limit, and it failed in the laboratory test, and the product should not be consumed as it would cause cancer and various other health complications. Learned advocate submitted that Jhandu is a herbal metal mineral formulation manufactured by the petitioner under a valid drug license, and its ingredients needs to comply with the standard as envisaged in the Ayurvedic Pharmacopoeia of India and other first schedule books, and there are limits of mercury and lead application for herbs, and this petitioner duly obtained the drug license with respect to the product only after undergoing rigorous testing process, and the petitioner has also obtained advice from Professor Dwivedi, coordinator, Government Ayurvedic College, Patna, and his letter is annexed as Annexure J, and confirmed that the product Jhandu, containing two metallic mineral bhashmas, namely Swarna Bhashma, Yashad Bhashma, and one mineral ingredient, namely Shilajit, and the testing and limits of heavy metals do not apply to this formulation. Now, my lord, I will show these opinions. My lord, it says that yes, heavy metals, mercury, lead, these are inapplicable for ashwagandha, because this ashwagandha, the product of the plaintiff, it has shilajit, then bhashmas, two bhashmas. These bhashmas are named here Swarna and Yashad. So Swarna and Yashad bhashmas and Shilajit will diffuse the effect of mercury and lead. My lord, I ask myself this question, that why will I take and consume lead and mercury along with these bhashmas so that the effect is ultimately zero? Why will I take it in the first place? My lord, if I may continue, the learned advocate also contended that the product Jhandu is an Ayurvedic medicine under the Drugs and Cosmetics Act and is not a food product. And the purported limits as alleged by the respondent number 1 is malicious, incorrect, and entirely false. And the respondent number 1, who is having commerce background, is not entitled to act as an influencer advertising in digital media as per guidelines and as per the definition of an influencer. And he was served with an advocate's notice dated 17th April 2025, whereby he was directed to withdraw his both videos, and in reply to the said notice, on behalf of the defendant number 2, such and such wrote to the petitioner and his advocate that his client took down the videos dated such and such on 21st April with reserving the right to re-upload the same and modified video after incorporating your comments. So, my lord, that the learned judge has taken note of, my lord, my reply, but only to the extent of taking down the video.
What is this? These guidelines? What are these guidelines? You cannot
My
be
lord,
an influencer.
this is the influencer guideline, my lord.
There is a guideline in place
There
that
is a
has statutory effect.
They have relied on a guideline, my lord. It has no, my lord, my lord, question the statutory effect of that guideline, but they have, my lord, relied on a guideline, my lord. My lord, and my lord, I will show, my lord, a judgment of the Honorable Delhi High Court where I am, my lord, arrayed as defendant by San Pharma, another company, my lord. There also I have made a video, my lord. The Honorable Delhi High Court has refused to pass ad interim order of injunction against me, my lord. I will show that order, my lord. There, my lord, same,
If we put in the details of your defense
my lord.
in our judgment, and you can go and publish as that judgment,
My lord,
that would be sufficient. We dismiss your appeal, but in detail record your submissions regarding heavy metal content and all.
my lord, I
Publicize that. It will be public record. You are not. No, it's just joking. Yes. So you have to satisfy us on 2 counts that these
Hello.
drug license, they take 3 defenses. One is the drug license, they have a drug license under the uh, appropriate authority, competent authority, which is appropriate, apparently the Ayurveda, something to do with Ayurveda.
My lord.
So that, secondly, this Shilajit Swarnavasya, that those neutralize.
Yes.
And thirdly, that you are not eligible to be an influencer,
lord.
that also you have to satisfy.
My lord. Yes, my lord.
These are the 3 grounds taken by them.
Yes, my lord. Whether, my lord, these grounds can at all be a reason for grant of ex parte order, my lord, and my lord, when in a defamation suit, because my lord, in defamation suit, my lord is well aware that Bonnet test has to be applicable, which says, my lord, no injunction ex parte at the ex parte stage. It has to be upon trial.
Yes.
Now, my lord, if I may, my lord, continue with the order.
Yes, yes.
Learned advocate also contended that the impugned video and the contents thereof are defamatory to the petitioner goodwill, reputation in general, to the product in
You can
particular.
skip this paragraph, you have read it. Defamatory and all.
Very
Yes.
well. Then, my lord, judgment shown. Now, my lord, kindly sees the next page, heard and considered. I have gone through the case record and endorsement of Sheristadar that no caveat. My lord, no caveat. My lord, with the greatest of respect, my lord, can that be a ground to, my lord, pass ex parte order, no caveat?
No, that's put in bold letters, so that must be a ground.
My lord, if I may, my lord, so my lord, this is the ground, my lord.
No, that's not the ground. That
That
is
is
one of
mere formality.
Of the grounds. Yes,
wrongly it was put in bold letters.
yes, yes. Now, my lord, if I may, my lord, show the ordering portion. This is a suit for disparagement, defamation, and perpetual injunction brought by plaintiff, wherein plaintiff has sought for relief primarily against different numbers 1 and 2 on the facts, which has already been described in short herein above. At the time of hearing, learned advocate representing the plaintiff has referred to Annexure C, which is the alleged video of the defendant number 1 and 2. Although there is no date found on Annexure C, documents and learned advocate, in order to disprove the alleged claim of the defendant numbers 1 and 2 with regard to Jhandu, a product of the plaintiff, has filed several documents including the expert reports and drug license, etc., wherefrom prima facie it appears that the product in question, namely Jhandu, is being manufactured under the drug license issued by the authority concerned, and therefore at this juncture there is reason to believe that the product in question of plaintiff company having batch number such and such is being manufactured as per.
Sorry. Please continue from there where you stop.
Category of Ayurvedic medicine, and therefore prima facie it is held that the claim of the defendant numbers 1 and 2 through the alleged video as uploaded on official YouTube channel around 26 March 25 falls within the realm of puffing and is intended to damage the goodwill which the plaintiff has earned over the years, and it's an act of slander. In this context, I would like to mention that defamation is intentional false communication, act of publication of defamatory content, either written or spoken, that harms reputation, including disagreeable opinions or feelings against the person or the thing.
There is apparently a confusion. Puffing is different from slander.
My lord.
Is a reverse actually.
My lord. My lord.
It counters an allegation of slander.
My lord.
Anyway.
My lord. From the annexures as filed by plaintiff, it appears that the defendant numbers 1 and 2 made his opinion about particular product of plaintiff company, namely Jhandu, which prima facie may be termed as an act of publication of content, seems defamatory because the defendant numbers 1 and 2, having no authority to make and publish any comment on any product which is being manufactured by the plaintiff company under a valid drug license issued by the appropriate authority. And if defendant numbers 1 and 2 feel aggrieved with the said product of the said company, they may approach to the authority issuing license to the plaintiff for manufacturing the particular product, but not in the way as alleged by plaintiff, and therefore the question of convenience and inconvenience is tilting in favor of the plaintiff, and accordingly, if the defendant number 1 and 2 is not restrained from making further publication the said video about product of plaintiff company which prima facie causing harm to the reputation of the plaintiff will suffer loss and injury. Thereafter, my lord, the ordering portion, if I may place, that the prayer for ad interim injunction is considered and allowed in part, and the defendant numbers 1 and 2 are hereby restrained from displaying, airing in any manner the impugned video or publishing in writing or speaking or in any other form any statement with regard to the product of the plaintiff in any manner in any media, including electronic media, till 3rd June 25. And my lord, this order is, my lord, still in force. It's been extended from time to time. Now, my lord, if I may show, my lord, their petition. My lord, kindly takes their petition. My lord, I have annexed it in my supplementary affidavit with annexures. That's why I will show from the supplementary affidavit, my lord.
Yes.
My lord, it starts at page 8. If I may show from page 17. My lord, if I may show, my lord, from page 17 of my supplementary affidavit, my lord, kindly takes paragraph 15.
Yes.
After the publication of the said YouTube post, the petitioner has received several complaints from the members of trade as well as public in general, and comments have been posted in relation to YouTube post that the petitioner's product should be thrown out and FSI officer should be sent behind the bars, and the subject product is hazardous and harmful and detrimental for consumption. Now, my lord, these are annexed as Annexure E, which my lord will find at pages 90 to 100 onwards. My lord, I will show, my lord, that not only me, there are other, my lord, independent fact-checking authorities, my lord, and my lord, YouTubers who have, my lord, done similar exercise, my lord, and my lord, the general public are also, my lord, influenced by that, my lord. In fact, in those complaints, they have stated that we have got to know about your product and this video from that particular video. So, my lord, this, my lord, now it's in the my lord, public domain. Now it's in, if things are in the public domain and there are other influencers also who have made similar videos, then it cannot be pinpointed that because of me, the defamation happened. And my lord, there is no case that they have filed similar defamation suit against those particular entities. My lord, kindly see page 90. This is, my lord, from their own, my lord, injunction application that I am showing. My lord, this, my lord, email from one of the consumers, my lord, he is writing, my lord, kindly, my lord, considers the second para.
As per.
My lord, the second, page 90, my lord.
90, yes.
My lord, the second paragraph, Unbox Health, my lord.
Yes, that will. Great.
Yes. Unbox Health, my lord, this is a different, my lord, YouTube channel, my lord, YouTuber, my lord. They have, my lord, this particular consumer is, my lord, relying on their video. Unbox Health is an independent third-party random quality checker recently published a lab report of Jhandu Ashwagandha. My lord, thereafter, my lord, the lab report details, my lord, if I may, my lord, very briefly take, my lord, through that. This is different lab reports.
Understood.
My lord, also they have done through Eureka and Eurofin. Eurofin is common for both of us, but that report, my lord, is also annexed to the injunction petition. Those reports were, my lord, dated prior to the reports that I am relying upon. And, my lord, similar results, high content, alarming high, my lord, rate of lead and mercury, and lower content of ethanol. The thing which has to be there in, my lord, higher proportion, that is, my lord, in lesser proportion, and, my lord, the lead and mercury is in higher.
Right.
My lord, if I may show, page 90, Ashwagandha sample, batch number such and such, sample number such and such, tested by Eureka Analytical Service. My lord, this batch and this, my lord, number, these are different from my test
Yes,
reports.
understood. Yes.
And the results raise serious safety concerns regarding heavy metal contamination. The lab reports indicate lead PB 6.677 mg per kg. This is Eureka's report. And my lord, 9.02 mg per kg Eurofin. Mercury 8G.
Mercury is close to yours.
Yes.
It's,
Yes, my lord.
Eurofins is higher. Eureka is close to yours,
My lord.
and Eurofins is higher.
My lord.
Lead less than yours,
My lord.
your initial report, but
But my lord, Eurofin is my lord.
common.
Yes, 9.02.
And Eurofins 9.02 for them, but in your
14 and 16.
14 and 16
My
years.
lord.
Anyway, so we
My lord. Total ethanol, this is my lord more or less 0.50.
right.
Okay,
That is similar.
yes. My lord, and Eurofin is separately done for that my lord 0.05 mg per 100 gram. As per FSSI standards, the permissible limit for lead is 10 mg per kg, but the mercury levels are alarmingly high and pose a significant health risk to consumers. Immediate actions required. Clarification on how this batch passed your quality control despite high heavy metal content. Then official documentation on safety compliance for this product. Immediate recall or corrective action, failing which I will be compelled to escalate this matter to FSSI authorities for regulatory intervention. And he has also attached the lab reports. This is different lab reports. If I do not receive a satisfactory response within 2 days, I will be left with no option. My lord, so many of the consumers, they are concerned. They are raising their concern with them only, their customer services.
Yes.
My lord, and my lord, it's a legitimate concern that they are raising. My lord, now, my lord, asking question is not defamation. And my lord, these consumers, they are actually asking questions that you explain. Then, my lord, that is the thing, my lord. It's not defamation. Now, my lord, kindly sees the reports are, my lord, are annexed, my lord, page 91. These are the reports that the consumer was, my lord, relying upon by a different YouTube channel. Page 92, my lord, thereafter, page 93 is the consumer complaint.
That's a different consumer based on a different video.
My lord, this is my video. This is 93
Yours.
is my video.
But 93 refers to Trustified, uploaded by Trustified.
My-
You are not Trustified.
Trustified. My lord, if I may show, my lord,
With Trustified already.
yes. My lord, if I may show, my lord, 93. My lord, this consumer is writing, I am regularly taking your Ashwagandha Gold Plus capsule since last 20 days. Now in YouTube, a video has been uploaded by Trustified, where he claims that the product is heavily loaded with metals, specifically lead and mercury. That too in much higher quantity than approved limit. His claim is supported by lab test reports. Link to the video is given below. Is your product safe? This is not expected from a reputed company like Emami. So, my lord, he is asking question. Now, my lord, kindly sees the next page, page 94. Another, my lord, consumer. Hello, I have been a regular buyer of your products since almost a year. I was disappointed when I came across a social media content that claimed through some lab test
This is
reports.
also your video link.
This is mine. This is mine. That product Ashwagandha Gold is contaminated with cancer-causing heavy metals. As I have bought that particular product for me and family, I seriously want answers to some of the questions listed below. Well, they are all asking questions.
But that is on the basis of your video only.
Yes.
So their goodwill they're saying is being affected by your video, which is substantiated by this.
My lord, yes, but my lord, I am still, my lord, armed with, my lord, defense of truth.
No, those arguments remain.
My lord.
On the goodwill aspect only.
My lord.
Apart from page 90, most are on the basis of your video only.
My lord.
So their goodwill is being affected.
My lord, asking question is not affecting video.
No, asking question is what are the questions? Just see.
My lord,
not expected from Emami.
Yes.
And after asking this question, it's not expected that that person will buy this product again.
Yes. My lord, they are asking.
There's a direct connect between the question and the goodwill of the product.
My lord, if my lord kindly sees page 94, the questions, my lord, which are, my lord, query raised. Do you have any proof? rubbishing the claim of heavy metal contamination of the above product.
So you are saying that they are only asking questions,
Yes.
questions regarding the validity of your video only,
Yes.
which they can also always answer.
Yes. My lord, there are no documents in their injunction application where they have, my lord,
Answered.
yes. Now, my lord, the next question, what are the testings you do on the above product before market release? My lord, that is all, my lord, this, my lord, my lord, this is all about, my lord, it's actually to, my lord, raise awareness amongst the consumers. My lord, they are taking, my lord, supplement. That is on the
This
basis
is the
of
precise purpose of the video actually.
Yes.
So the people ask questions and they have to answer.
Yes. My lord, they are buying a product, my lord, after watching advertisements in the TV, social media. My lord, Emami also does, my lord, publishing of the new products are launched, my lord. So, my lord, when Emami has a right, my lord, to, my lord, puffing or advertise their new products, my lord, and people are, my lord, influenced by that. Similarly, if there is a counter, my lord, a balancing, my lord, setup is there.
If they have a
which
right to inflate,
raises
you have a right
question,
to deflate also.
my lord. And my lord, we have, my lord, stated that we are, my lord, result agnostic. My lord, that is the reason we tested twice. My lord, that is the reason, my lord. So, my lord, the purpose is, as my lord has, my lord, rightly, my lord, pointed out, purpose is to raise awareness, and this is what the consumers are doing. And my lord, this is an age of, my lord, Consumer Protection Act.
Page
Now,
96 says the ear ringing has increased.
yes,
Page 96, another consumer writes that after
my lord, I was,
prescribed that for a particular purpose, but that has increased after taking the products.
yes,
But this is apparently influenced by your. Before the video, he was not aware that his condition has
he
increased.
could relate to the video now, because my lord, he was sensing something. Now the video, my lord, kind of proves that yes, my lord, probably the
Valid.
valid.
No, your argument is valid. Legitimate. Yes.
My lord, that is the purpose, whole and sole purpose, my lord. And my lord, previously, my lord, the principle was buyers beware. But now, my lord, the principle is, my lord,
No, this is an extension of that.
yes,
You're only making them more aware of what they should be aware of.
absolutely, my lord, absolutely. That is, my lord, my object. There is no other object.
Understood?
My lord, if I may now show, my lord, the next, my lord, page 96. My lord, this is also, my lord, as my lord has already
Yes, 96 is ear ringing.
seen, ringing.
Got over it.
So, my lord, and again, my lord, 97 and 98, he has relied on, my lord, the reports which are by the other YouTube channel, not by me. Now, my lord, this is, my lord, so far as his injunction is concerned, injunction petition. Now, my lord, if I may show, my lord, there, first, the storyboard, because that is, my lord, the impugned video.
Yes.
My lord, the storyboard, they have annexed, my lord, with their injunction petition.
Yes.
My lord, that is at page, my lord, 79 it starts.
Yes.
This is the impugned video, my lord, according to them. My lord, at the bottom, my lord, will find the contents of the video they try to transcribe. This product will cost you such and such, in which you get a. So, my lord, they start the storyboard, if my lord kindly sees, from 0.39 seconds.
Yes.
Seconds.
The disclaimer is skipped.
Yes, disclaimer is skipped. And not only that, my lord, just above this YouTube video, there is a description box where, my lord, there was another disclaimer. That is also skipped by them. My lord, I will show, my lord, from my stay petition, what was the, my lord, display board showing and what was the description box showing. Now, my lord, what they are relying on,
Yes.
what they are relying on is on top of the video. If my lord kindly sees, it's written in bold, my lord, Jhandu Ashwagandha Gold Lab Test Report. Then,
Where, which page? That page.
my lord, page 79.
Yes.
My lord, on top, my lord,
Test report. Yes.
yes, lab test report, then poison in bottle question mark. This poison in bottle question mark, this is what they are saying is defamatory and disparagement. My lord, now my lord, if my lord kindly sees 80, it goes on. 80, my lord, the content was cost of one capsule will be 6 rupees, in which company claims to be 200 mg ashwagandha. Primary compound of ashwagandha is withanolide. According to researchers, 300 to 600 mg ashwagandha per day, which is standardized with at least 5% withanolides. The best method to test withanolide is HPLC. This goes on, my lord. My lord, so my lord, this is the content of the video. Now, my lord, from page 82,
Yes. They claim to be there to be 200 milligrams.
of ashwagandha per capsule.
Yes. Very well.
Now, my lord,
You found that the content of ethanol is only 0.5 milligram.
my lord. Now, my lord, page 82, if my lord kindly sees, this
Yes.
is where the test report is, my lord, vis-a-vis, my lord, withanolide is published.
Yes.
This is withanolide, my lord, test report. Then, my lord, page 83, this is for the heavy metal testing report. My lord, 4 my lord, heavy metals are found: arsenic, mercury, lead, cadmium. Out of these 4 heavy metals, arsenic and cadmium were within the permissible limits. My lord, lead and mercury were my lord, far exceeding. My lord, that's what we pointed out.
What is LOQ?
LOQ is limit of quantification.
All right.
If
Yes.
my lord takes page 91 of the supplementary affidavit, my lord will find just at the bottom of the analytical report, LOQ is, my lord, the legend of LOQ.
Legend is there. Yes. Right. Right. Thank you.
My lord, 82 onwards, the storyboard starts, and my lord, the report itself was part of the impugned video. Now, my lord, now, my lord, when the storyboard ends, my lord, we have given, my lord, page 86 also, if my lord kindly sees, this is the result that we have published.
These are all annexures to their injunction application.
Yes. This is that impugned video, which, my lord, they have got
Yes.
an injunction. So, my lord, 85, my lord, is the other report, my lord, of the second testing. My lord, we have also, my lord, named the entity, the lab test, through which the lab testing was done. And, my lord, finally, my lord, if my lord kindly sees page 85, arsenic, my lord, limit is 1.1 mg per kg, found 0.14 mg per kg. So, my lord, it's in green because it's within permissible. Cadmium also, my lord, permissible because found, my lord, 0.12. Limit is 1.5. But, my lord, lead, so far as lead is concerned, it's in red because, my lord, this is exceeding. And similarly, my lord, we have done for mercury, that's at page 86.
So you say permissible limit, IOQ is 0.02 mg. Cadmium, but this is
Cadmium?
0.12 mg, 12.
Yes. But so far as cadmium and arsenic are concerned, they were found to be within the permissible limit.
Doesn't appear to be so. 0.5 is 5. LOQ is 5.
My lord is looking at 85.
85.
But-
Arsenic,
Yes,
result unit is 0.14 milligram
my lord.
per kg. LOQ is 0.05 milligram per kg.
My lord, if my lord kindly sees the limit, my lord, limit is 1.1 for my lord in the box of the video.
Acha, acha.
The video itself.
The limit and LOQ are different things.
My lord, limit and LOQ. Yes, my lord. I think they are same, one and the same. If I may, my lord, cross check.
Should be, but then it's the box. The limit shown in the box is different from the LOQ for arsenic and cadmium.
Yes, my lord.
1.1 mg is shown as the limit in the box,
Yes.
arsenic, but LOQ says 0.05, even less than that. We don't understand this anyway. Limit of quantification, maybe not, the unit may be different, we don't know. Unit must be different.
Yes, my lord.
Yes, page
That's
91,
yes, yes, yes. My lord, because my lord, the unit taken is out of 100.
maybe something percentage
yes,
sort of.
Yes.
All right, very well.
My lord, now, my lord, kindly sees the storyboard, page 89. My lord, so my lord, they are saying that this face, the grimace in the face, and then cancer and lead, this tantamounts to disparagement and defamation. So, my lord, this is their contention, and this is the impugned video. Now, my lord, if I may show their, my lord, notice, the legal notice that they have issued first. My lord, kindly sees page 49 of my stay petition. My lord, this is, my lord, their advocate's letter dated 17th April 2025. My lord, which is almost after, my lord, 1 month from the date, my lord, when the video was uploaded. My lord, this is also my second limb of submission, that, my lord, when the video was uploaded and, my lord, the date when the suit was filed, my lord, 2 months
No
have...
later, their stand is that they came to know from the communications by their consumers and all. So they came to know later,
Before uploading the video, I have, my lord...
given a notice to them.
Yes. On 25th March, I have given a notice to them, my lord. My lord, now, if I may show, my lord, their legal notice. Reference, my lord, is publication of your video in YouTube in respect of product Jhandu Ashwagandha. Then, my lord, I will not trouble, my lord, with para 1. My lord, kindly sees para 2. Recently, my client has come across videos uploaded by you in YouTube showing my client's Ayurvedic medicine, Jhandu Ashwagandha Gold Plus, and conveying certain purported information about the said product, which are incorrect and false. You have done some testing of the aforesaid medicine of my client for ascertaining heavy metal content in them and compared the results with limits as set for unspecified food products by FSSI, being lead 2.5 ppm, arsenic 1.1 ppm, mercury 1 ppm, cadmium 1.5 ppm. However, my client's product Jhandu is an Ayurvedic medicine under Drugs and Cosmetics Act and is not a food product. As such, the aforesaid limits as quoted by you and the comparison are incorrect and false. The said product of my client, being an Ayurvedic medicine, is manufactured under drug license under such and such act and is in full compliance of its applicable laws. The formulation is a proprietary and herbal metallic mineral formulation with various herbs, metallic and mineral compounds as mentioned in various Ayurvedic pharmacopoeia as its ingredients. You may check on the label of the said product that it contains Swarna Bhashma, Yashad Bhashma and Shilajit, etc., which are all metallic and mineral compounds. The product ingredients, manufacturing process and its labels are in full compliance of law. Your video is not only containing false data, but also highly disparaging the said medicine of my client, whereby you have indicated on the cover of the video that the said product is leading to cancer. You have also indicated that the said product of my client is poison in bottle. Your such malicious viral campaign has brought immense disrepute to my client's said brand, which is created upon spending huge quantum of money. You have also violated and infringed the trademark of my client by showing my client's product label with an intent to create your fanfare and make people believe in your false contents and subscribe to your channel. Moreover, you have violated the relevant ASCI. This is that influencer code, which requires the person speaking about health products to be qualified with a medical degree and qualified nurse. Pertinent to mention that your LinkedIn profile does not mention any such degree, My lord, I am a sports, my lord, science nutritionist. And my lord, I am a certified personal trainer, my lord. That, my lord, is, my lord, recognized in the Honorable Delhi High Court judgment. I will show. Now, my lord, it says you are hereby directed to withdraw both the videos. Now, my lord, kindly sees my reply to this. My lord, page 51, 22nd April, I write through my advocate. My lord, kindly sees this reply. My lord, page 52, my lord, onwards, if I may show. My client is a company focused on ensuring quality and safety of health products and supplements through rigorous lab testing. The company assesses label accuracy and tests for the presence of heavy metals, chemicals, and other adulterations. The primary objective of my client is to protect consumers from fraudulent manufacturers and adulterated products that can cause severe health ramifications on the consumers. To that end, my client tests products anonymously to maintain the integrity of the testing process and lists both products that pass and fail scientific tests, offering consumers transparency in a market filled with non-regulated products. Thus, my client performs a vital function of public interest to ensure accountability and transparency. That my client has a transparent testing process which has been published on its website, Trustified, and is uniformly applied to all products audited by my client, which is as follows. Identification of product. My lord, this is the process, my lord. It's very important, my lord. If I may, my lord, read this. My client identifies a product for testing based on polls conducted on its website, as also on the basis of complaints and requests it receives from consumers, and on the basis of requests received from manufacturers to audit their products. Blind testing. In order to ensure the integrity of the process, all products are ordered in sets of 2 using pseudonymous names, and the entire process of ordering is screen recorded and the recording thereafter stored for verification or legal scrutiny. Thereafter, at the time of delivery of the product, the process of unboxing is also recorded to ensure that the product that was ordered is the one that is delivered and to match the batch number of the product received. Then sealed product testing. My client thereafter submits the company's sealed products as received for testing with accredited and well-reputed testing laboratories. The lab that receives the product confirms in each report that the product received was in its original trade pack, complete with batch number, manufacturing date, and expiry date. Reporting. My client being result agnostic reports on the findings of the scientific laboratory testing conducted by third-party laboratories on its website as also on its YouTube channel. Then comments. Upon receiving the sample results, my client, as a matter of abundant caution, communicates with the manufacturing company of the tested product via email. This communication seeks the manufacturer's comments on the results obtained. As per policy, my client waits for a response from the manufacturer for a period of 24 hours following the dispatch of the email. If no response is received within this time frame, the results are then uploaded on my client's social media platforms and YouTube channel. However, if the manufacturer provides a response within the specified time period, their comments are duly incorporated into the video before it is published. Challenge to the results. My client has a dedicated tab on its website at http://trustified.in. Can you challenge Trustified? To enable any manufacturer to challenge the results and reports relied upon by my client in any of its videos or publications. If a manufacturer challenges the test results, my client, as a matter of policy, conducts a retest using either another sample of the same product from the same batch or the excess sample stored by the laboratory at the time of initial testing. If there are considerable deviations found from the first report, my client updates the results on all its sources. That on the basis of a number of requests from consumers, my client following the same testing model, shortlisted your client's product, Jhandu, Ashwagandha Gold Plus, for audit laboratory testing. That my client purchased 2 packs of your client's product having the same batch numbers under a pseudonymous identity from a third-party seller through the Amazon website against valid receipts and recorded the entire process of placing the purchase order. That my client also recorded the unboxing of both the products and noted the batch numbers of the product, which was such and such, having manufacturing date October 24, date of expiry September 27. That one sealed unit having batch number such and such was thereafter sent to Eurofins Analytical Services India Private Limited, which is an FSSI notified NABL and IAS accredited laboratory for testing of the content of ethanol and heavy metals in your client's product. That your client's product was tested on 2 levels. The first level testing was done to determine the content of ethanol in your client's product, while the second level of testing was done to determine the content of heavy metals used in your client's product. It is pertinent to mention at this juncture that one of the main components of ashwagandha that contributes to its numerous health benefits is ethanol. The test reports issued by Eurofins Analytical Services India Private Limited after level 1 testing painted a concerning picture of your client's product. The analysis revealed that the product contained only 0.600 mg of ethanol per 100 gram. It is, my lord, I think, my lord, it should be 60. I think I said 50. 50 was in other.
I've noted that, yes.
My lord. It is pertinent to note at this point that according to researchers, ashwagandha dosage of 300 to 600 mg standardized to 5% ethanolides provides the greatest advantages. Hence, it is evident from the lab test report that ethanol content in your client's product falls significantly short of the levels expected in a standard ashwagandha product. That although the ethanol content in your client's product fell significantly short of the levels recommended and generally advised by various scientific research papers, my client, considering the lack of statutory regulatory standards being set by the relevant regulators, to the best of my client's knowledge, did not classify your client's product as failed on this ground. However, the test reports issued by Eurofins Analytical after level 2 testing revealed an even more alarming situation regarding your client's product. The analysis detected 16.98 mg per kg of lead and 7.28 mg per kg of mercury in the product. These levels.
You tested on the parameters of the Ayurvedic pharmacopoeia itself.
My lord.
So under which they obtained the drug.
My lord. My lord. They say that it's the
food product and medicine.
Yes. And my lord, they also say that the Ayurvedic pharmacopoeia I rely upon, the chapter is different.
Oh. Food.
Yes.
And theirs is medicine.
Medicine. Now, my lord, if I may, my lord, read on. These levels far exceed the permissible limits prescribed under the Ayurvedic Pharmacopoeia of India, which sets the maximum allowable limit for lead at 10 mg per kg and for mercury 1 mg per kg in Ayurvedic products. Well, in fact, in the Amazon, they sell this product under the category Ayurvedic medicine. Thus, it is evident that the quantity of lead present in your client's product exceeds the permissible limit by 69%, while the mercury content surpasses the prescribed threshold by an alarming 628%. A copy of the lab test report issued by Eurofin dated 7th March 25 Annex 2 and marks such and such. Copy of the Ayurvedic Pharmacopoeia specifying maximum allowable limits for lead and mercury in Ayurvedic formulations, Annex such and such. Then, my lord, if I may read para 13. To verify the initial results, my client got your client's product tested again specifically for level 2 heavy metals analysis. The retest was conducted using the same sample of your client's product bearing batch number such and such. It is significant to note that the result of this subsequent test reaffirmed the findings of the initial test, as the levels of lead and mercury were detected at 14.52 mg per kg and 8.45 mg per kg respectively. Thus, the second test also makes it evident that the content of lead in your client's product is 45% more than the recommended level, and the content of mercury is 745% higher than the recommended level. Then, my lord, we annex the second test report also, 15th March 25. A cursory examination of the reports indicates material inconsistencies between test results and the quality standards your client's products was obligated to meet. It is evident that your client's product not only contained lower levels of ethanolamide but also exhibited alarmingly high concentration of heavy metals, specifically lead and mercury, both of which far exceed the recommended limits. It is pertinent to note that my client has classified your client's product as failed solely on account of excessive presence of heavy metals, namely lead and mercury, such and such. It is crucial to note that my client, as a matter of abundant caution, conducted 2 separate rounds of testing specifically for your client's product. However, in both the tests, your client's product failed to meet the standards claimed by it. This double verification was conducted to eliminate any margin of error and to reaffirm the results. The consistent failure in both reports also only strengthens our position that the information we provided to the public is both accurate and reliable. It is pertinent to note that the video speaks for itself and my client has nowhere made misstatements regarding your client's product. Furthermore, by testing your client's product twice, my client has eliminated any possibility of erroneous results and has thus, by publishing the results of the tests, acted in the interest of fairness, public interest, and in pursuit of its journalistic freedom. It is further crucial to note that my client has also clearly provided a disclaimer. Well, this is the disclaimer. It starts from 0.18 second to 20 seconds.
So for 2 seconds.
For 3 seconds.
19, 20.
18, 19, 20.
18 cannot be counted. From 18 starts from 18.
My lord.
19, 20. 2 seconds.
Very well, my lord. My lord, if I may show, my lord,
Read this in 2 seconds and show us. Read the entire thing in 2 seconds. Read it out.
That the, my lord.
Anyway, you can always pause the video.
Yes, my lord.
Who pauses for the disclaimers?
Screenshot also. Take a
No,
screenshot.
nobody pauses for the disclaimers. Yes. How many disclaimers do you pause for?
My lord, disclaimer. My lord, I read disclaimers.
You got an exception there. I never read disclaimers. Yes.
My lord, if I may, my lord, read this disclaimer. My lord, it says the information provided here and on our affiliated website.
Disclaimers we have seen. We have covered every possible.
And the description box, my lord, is at para 19. We have, this is the description box disclaimer.
Yes.
It reads, my lord, conduct their own research and not rely solely on this video for purchasing decisions. And my lord, some of the consumers, my lord, they have also they have a report. So my lord, now there are, my lord, 5 reports.
Including those email referred to.
Yes. Total 5 reports. Everything saying lead and mercury. My lord, is excessive. Now, my lord, if I may show, para 20. At this juncture, it is crucial to note that in order to ensure transparency and to provide your
This
client
that you 24 hours given.
24 hours, and the email was annexed. It is also part of the, I will show that email. We asked for, my lord, their comment on the video. No reply. That it is also noteworthy that your client has never challenged the results of the reports and tests conducted by my client as published on the website, which your client is fully aware. My lord, that can you challenge Trustified? They have not, my lord, challenged. Then, my lord, we have said, and this is what the learned trial judge has relied upon, para 22 only. Without prejudice to the above, in view of your letter dated 17th April, my client has decided to treat the contents of your legal notice as a reply to the email of 25th March. My lord, kindly cease. We have been, my lord, very, my lord, prudent in this regard. Accordingly, without prejudice, my client voluntarily and without acceptance of any fault or liability took down the video.
Yes.
on 21st April 2025 while reserving the right to re-upload the same modified video after incorporating your comments or by making any such modification as he deems fit. Accordingly, your client is called upon to provide detailed comments on or before 24th April. Now, my lord, to which their reply is page 61. My lord, 24th April, they, my lord, wrote this, my lord, reply to our letter. My lord, if I may show from para 2, my lord, onwards. That in your reply, you have relied upon and attached part 2, Formulations Volume 2 of Ayurvedic Pharmacopoeia of India for specifying the maximum allowable limits for lead and mercury in Ayurvedic formulations. This is to inform you that said part 2 Formulations Volume 2 of Ayurvedic Pharmacopoeia of India is not applicable on my client's product Jhandu. It transpires that your client seems to lack any subject knowledge about Ayurvedic Pharmacopoeia of India and medicinal products. Then, hence, any statement video by your client towards denigration of my client's above said product brand based on the above document stands to be and would be false without basis. Any such content being materially false denigration of my client's product brand is unlawful. My lord, kindly sees there is no response. I have written, my lord, 10-page letter response with all documents. My lord, they did not challenge, my lord, take an exception to the report. Only says Ayurvedic pharmacopoeia not applicable. Now, my lord, I have, my lord, answered this also. My lord, kindly sees page 63. This is my response on 2nd May 2025. This is when they have filed the suit, 2nd May. My lord, if I may read, my lord, from this email, this is regarding our video dated 26 March 25, where we tested your product, found lead such and such, mercury such and such. We received an email from one of your legal representatives stating that the permissible limits of FSI and API will not be applicable for this product as it is not food and falls under Drugs and Cosmetics Act. Without prejudice to our rights and contentions, we have made the video private to have more clarification on this matter so that we can update the viewers. Requesting you to please provide your answers question-wise so that consumers are well informed on the health matter. Question 1. The product's label claims that the suggested dosage is 1 capsule twice daily. Given the lead and mercury levels found in our lab test, is it really safe for long-term use if a person takes 2 capsules daily? Then question 2, how come the presence of gold in Swarna Bhashma exempts the product from meeting established heavy metal standards? Given that the API Part 2, Volume 2, which outlines acceptable limits for heavy metals like lead and mercury, applies to all Ayurvedic formulations, including compound formulations like Jhandu, which contain both herbal and metal-based ingredients. Then question 3, even though it does not fall under FFSI limits since it is not food, why are limits set by API not applicable when it is well known that the safety of such formulations depends on strict adherence to permissible limits for metals like lead, arsenic, cadmium, mercury, which are clearly outlined in WHO and Indian regulatory guidelines? Question number 4, given that the brand company has classified this product on Amazon under the Ayurvedic category and has used the terms Ayurvedic and Ayurveda at least 100 times across all its online listing pages, why are the API limits irrelevant? Also consider the listing. How come the products still come under Drugs and Cosmetics Act? My lord, to this, my lord, there is no answer.
Yes, there is an answer at the bottom.
My lord, that is
Treat it to be a customer complaint.
and 26 March, my lord. This is their my lord, this.
They treat your letter to be a email to be a customer complaint. They say that would like to inform you that you can contact for your concern related query at our customer care ID.
My lord, but my lord, this email is
Was underestimation of your client.
Yes.
You sue them for defamation. You are a content creator and you are treated as a customer and you are referred to customer care for this.
My lord,
No, one question, Mr. Koti, you referred to in this reply, rejoinder to reply.
my lord,
You say that not only FSSAI limits but also API limits.
my lord.
But apparently all your labs are accredited by FSSAI or
NABL accredited.
NABL.
Yes.
So how is how does API come in?
My lord, because my
Where,
lord,
where are the API accredited labs or API standards? We don't
My-
find it in your lab reports.
my lord, if I may show I have annexed, my lord, the API.
Where is that?
Yes,
Either the API standards being mentioned in the lab reports
yes.
or something like that.
My lord, kindly see page 44 of my stay petition. My lord, this is, my lord, the API Part 2 Volume 2 formulations issued by the Government of India, Ministry of Health and Family Welfare, Department of Ayurveda. Now, my lord, kindly see page 45. Limit tests. Permissible limits of heavy metals. Now, my lord, heavy metal permissible limits, my lord, lead is 10 ppm, arsenic 3 ppm, cadmium 0.3 ppm, and mercury 1 ppm. My lord, these are, my lord, the limits, my lord, prescribed by APPI. My lord, this is what I am relying upon. And my lord, if I may also show,
These are applicable to what? We don't find it, only one page is given here.
my lord, these are,
They say volume 2 does not apply to them. Part 2, volume 2 does not apply.
yes, my lord,
So what does this part 2 relate to? Formulations regarding what? They try to distinguish between medicine products and this food products.
food product.
So
Yes,
where
my
do we
lord.
get that? I mean, part 2,
My lord, I should have annexed the, my lord, full volume.
at least the definition of,
Yes,
I mean,
yes, my lord.
what is
Yes,
the
my lord.
applicability? Do you have a copy of that? I mean, that would
My
be
lord,
better.
Yes,
They take a specific point on this.
Yes,
That
my
this is not applicable to their medicine.
my lord, my lord. My lord, this
Have a
would be
copy of that. It will be helpful if you look it into that.
absolutely, my lord. I am just, my lord, getting a copy of, my lord, this report.
Since Mr.
Yes.
Ghosh will in any event reply on the next day, we'll just you can complete your arguments right now,
My
and
lord.
we'll just take your argument on that only on the next.
My lord, very well.
Let us proceed on whatever you have. Yes.
Very well. I am grateful, my lord.
So from this, it is evident that they have exceeded the permissible limits.
My lord. My lord, and my
It
lord,
will also be helpful if you bring those, because you have to rely on your part 5.
My lord, we have already disclosed in the injunction application. It is disclosed.
not part 2.
The ones which are relevant to our product
That
has been disclosed.
We'll good.
My lord.
Part 2, my lord, and how it is applicable. My lord, now, my lord, if I may show, my lord, in the injunction petition, or my lord, from the plaint also I can show, my lord, kindly sees page, my lord, 76. This is part of their plaint. My lord, this is, my lord, reiterated in the injunction. So, my lord, I am just showing from the plaint. My lord, page 76 of my stay petition.
Yes.
My lord, paragraph 22, my lord, this is their answer to the heavy metal, presence of heavy metal in ashwagandha. Para 22, they are saying, plaintiff has obtained advice from Professor Prabhat Kumar Dwivedi, coordinator, Peripheral Pharmacovigilance Center, Department of Rasha Shastra, Bhoishojo Kalpana, Government Patna College, for opinion on the applicability of compliance with heavy metals for Harbo Mineral Proprietary Ayurvedic formulation Jhandu Ashwagandha Gold Plus capsule. The said expert has advised inter alia as follows. Since Jhandu Ashwagandha Gold Plus capsule contains two metallic mineral bhashmas, namely Swarna Bhashma, Yashad Bhashma, and one mineral ingredient, namely Shilajit, in my opinion, the testing and limits of heavy metals do not apply to this formulation. My lord, and my lord, there is a second expert report, that is the next para, 23. The plaintiff has also obtained advice from the former technical officer consultant advisor to the Ministry of Ayush, Vaishali Ghaziabad, with regard to whether heavy metal limit is applicable to Jhandu Gold Plus, which is an Ayurvedic medicine manufactured under drug license, to which, my lord, the opinion is set out. Herbal mineral and herbal metal formulation has various minerals in their formulation. So it is obvious that the heavy metal content in those formulation will be high. Therefore, keeping in view, Ayush department has not mandated the heavy metal limit for herbal mineral and herbal metal formulation. The same is also substantiated by the above monograph and Ayush order dated 14th October 2005. Further, the exemption from heavy metal limit testing as given bhashma would also be applicable to medicine having bhashma as ingredient, because if bhashma is exempted from heavy metal testing, then obviously the said exemption also applies to formulation containing bhashma as an ingredient. Therefore, in my view, heavy metal limit testing is not applicable to Jhandu, which is having mineral Shuddhajit, Shuddha Shilajit and metals Swarna Bhashma and Yashad Bhashma. So, my lord, they are not denying that there is content of heavy metals. And my lord, alarming rate of heavy metals in the ashwagandha. They are saying since this capsule also has bhashmas, two bhashmas and Shuddha Shilajit, that neutralizes. My lord, that is the reason, my lord, I started off, my lord, by asking myself this question, that why I will consume heavy metals first and thereafter to neutralize that I will consume my lord bhashmas and shilajit. If the effect is zero, my lord, lead and my lord mercury, these are my lord heavy metals. These are my lord not my lord, these are not for consumption. My lord, and my lord, people are taking capsules per day. They are taking 2 capsules.
Yes.
This is, my lord, something which is very alarming. Now, my lord, kindly, if I may show the judgments, my lord, on this. My lord, and my lord, one more thing I wanted to show, that is my email, which I have issued to them before uploading the video. My lord, that email is, my lord, at page 156 of the supplementary affidavit. My lord, this was annexed by them in their injunction petition. My lord, here I write to them, we have conducted testing. My lord, we'll find the date.
25th March.
Yes. We have conducted testing on your product, Jhandu Ashwagandha Gold Plus, and have found elevated levels of lead and mercury above the safety limits established by the FSSI. If you have any response comment to this, kindly provide the same within the next 24 hours of receiving the email so that we may incorporate them into the video we intend to upload within the same time frame. To which, my lord, 26th March, Jhandu Care, my lord, their consumer, my lord, customer care, they have issued an email. Dear sir, would like to inform you that you can contact for your
But you address the email at the customer care team.
Yes. My lord, Care Jhandu. Yes, my lord.
All right, very well.
My lord. Now, my lord, the 2 judgments, if I may show, my lord, first I will begin with the judgment Zeta. Yes. Reported in 2025 1 SCC
You give
741.
copies on the last one.
Yes, my lord.
আচ্ছা বলুন দেখেন ডবল হয়ে যাবে ওখানে তলায় তো
minimum stay petition.
Yes.
My lord, if I may show, my lord, this is on the Bonnet test principle and applicability in, my lord, case of a defamation, my lord, suit, ex parte injunction order. My lord, if I may show, my lord, paragraph 1.
Yes.
My lord, 3 bench judgment, my lord. My lord, paragraph 1. Leave granted on 1st March 24, an ex parte ad interim order was passed by the ADJ 5 of the South Saket Courts, New Delhi, directing the appellants, a media platform, one of its editors, and the journalists concerned to take down an article dated 21st February 2024, published on their online platform within a week. The appellants were also restrained from posting, circulating, publishing the article in respect of the respondent plaintiff on any online and offline platform till the next date of hearing. Now, my lord, this ex parte order of injunction if my lord kindly sees paragraph 3. This has been upheld by a single judge of the High Court of Delhi by order dated 14th March 24. My lord, from that, my lord, appeal was filed before the Honorable Supreme Court. Now, my lord, if I may show from paragraph 4 onwards. My lord is very well, my lord, aware of, my lord, this principle. My lord, for my satisfaction, my lord, may I show. Paragraph 4. The threefold test of establishing prima facie case, balance of convenience, and irreparable loss or harm for the grant of interim relief is well established in the jurisprudence of this court. This test is equally applicable to the grant of interim injunctions in defamation suits. However, this threefold test must not be applied mechanically to the detriment of the other party and in the case of injunctions against journalistic pieces, often to the detriment of the public. While granting interim relief, the court must provide detailed reasons and analyze how the threefold test is satisfied. A cursory reproduction of the submissions and precedents before the court is not sufficient. The court must explain how the test is satisfied and how the precedents cited apply to the facts of the case. In addition to this oft repeated test, there are also additional factors which must weigh with courts while granting an ex parte ad interim injunction order. Some of these factors were elucidated by a three-judge bench of this court in Morgan Stanley Mutual Fund versus Karthik Das in the following terms. Then, my lord, Morgan Stanley, my lord.
Yes, yes.
My lord. My lord, if I may, my lord, now move on to paragraph 6. Significantly, in suits concerning defamation by media platforms and or journalists, an additional consideration of balancing the fundamental right to freedom of speech, free speech, with the right to reputation and privacy must be borne in mind. The constitutional mandate of protecting journalistic expression cannot be understated, and courts must tread cautiously while granting pre-trial interim injunctions. The standard to be followed may be borrowed from the decision in Bonnard versus Perryman. This standard, christened the Bonnard standard, laid down by the Court of Appeal, England and Wales, has acquired the status of a common law principle for the grant of interim injunctions in defamation suits. The Court of Appeal in Bonnard held as follows: that it is obvious that the subject matter of an action for defamation is so special as to require exceptional caution in exercising the jurisdiction to interfere by injunction before the trial of an action to prevent an anticipated wrong. The right of free speech is one which it is for the public interest that individuals should possess, and indeed that they should exercise without impediment so long as no wrongful act is done. And unless an alleged libel is untrue, there is no wrong committed. But on the contrary, often a very wholesome act is performed in the publication and repetition of an alleged libel. Until it is clear that an alleged libel is untrue, it is not clear that any right at all has been infringed. And the importance of leaving free speech unfettered is a strong reason in cases of libel for dealing most cautiously and warily while granting of interim injunction. In Fraser versus Evans, the Court of Appeal followed the Bonnard principle and held as follows. Insofar as the article will be defamatory, Mr. Fraser, may I show from the fifth line from bottom at para 7 that that has been established for many years ever since Bonnard versus Perryman. The reason for sometimes given.
The italics paragraph sentence is very important for you. The court will not restrain. You can read that also.
Yes, yes. My lord, I am very grateful, my lord. My lord, may I read? The court will not restrain the publication of an article even though it is defamatory when the defendant says he intends to justify it or to make fair comment on a matter of public interest. My lord, I am very grateful, my lord. That has been established for many years ever since Bonnard versus Perryman. The reason sometimes given is that the defenses of justification and fair comment are for the jury, which is the constitutional tribunal, and not for a judge. But a better reason is the importance in the public interest that the truth should be out. In essence, the grant of a pretrial injunction against the publication of an article may have severe ramifications on the right to freedom of speech of the author and the public's right to know. An injunction, particularly ex parte, should not be granted without establishing that the content sought to be restricted is malicious or palpably false. Granting interim injunctions before the trial commences in a cavalier manner results in the stifling of public debate. In other words, courts should not grant ex parte injunctions except in exceptional cases where the defense advanced by the respondent would undoubtedly fail at trial. In all other cases, injunctions against the publication of material should be granted only after a full-fledged trial is conducted or in exceptional cases after the respondent is given a chance to make their submissions. Now, my lord, may I place paragraph 10. The order of the trial judge does not discuss...
This is on the facts of the case.
Yes, my lord. But my lord, in paragraph...
Yes, understood. Please.
My lord, I'm grateful, my lord. The prima facie case strength of the plaintiff's case, nor does it deal with the balance of convenience or the irreparable hardship that is caused. The trial judge needed to have analyzed why such an ex parte injunction was essential after setting out the factual basis and the contentions of the respondent made before the trial judge. Now, my lord, if I may show, my lord, lastly, it says at para 10, if ad interim injunction granted by the trial judge amounts to unreasoned censorship which cannot be countenanced. Then para 11, undoubtedly, the grant of an interim injunction is an exercise of discretionary power, and the appellate court, in this case, the High Court, will usually not interfere with the grant of interim relief. However, in a line of precedent, this court has held that appellate courts must interfere with the grant of interim relief if the discretion has been exercised arbitrarily, capriciously, perversely, or where the court has ignored settled principles of law regulating the grant or refusal of interlocutory injunctions. The grant of an ex parte interim injunction by way of an unreasoned order definitely falls within the above formulation, necessitating interference by the High Court. This being a case of an injunction granted in defamation proceedings against media platform, the impact of the injunction on the constitutionally protected right of free speech further warranted intervention. Then, my lord, lastly, if I may show para 12, in view of the above, the High Court ought to have, in our view, also at least prima facie assessed whether the test for grant of an injunction was duly established after an evaluation of facts. Then it says, my lord, the next sentence, merely recording that a prima facie case exists, that the balance of convenience is in favor of the grant of injunction and that an irreparable injury would be caused, would not amount to an application of mind to the facts of the case. The threefold test cannot merely be recorded as a mantra without looking into the facts on the basis of which an injunction has been sought. In the absence of such consideration, we have no option but to set aside both the orders. My lord, both the orders were set aside. Now, my lord, if I may show one more judgment, my lord, because my lord, I didn't want to trouble my lord with...
You have a copy.
My lord.
You troubled on the last occasion.
Yes, I...
Yeah, but Justice Dev was not there, so you have
My lord.
just to be.
My lord.
You can start from para 53.
Yes, my lord.
You give the citation for your learned friend.
Yes. My lord, if I may...
And nutrition, it was cited on the last occasion.
My lord, before para 53, my lord, kindly also sees paragraph 16.1. This is at page, my lord, 6 of the report. And my lord, before my lord showing 16.1, if I may also show 15.17, my lord, there, my lord, impugned videos, 4 videos were there. And my lord, kindly see, my lord, so far as C is concerned, under para 15.17,
yes.
Video titled Doctor's Choice ISO Pro Scam. My lord, here, my lord, we have used, my lord, poison in a question mark, but there, my lord, scam. And my lord, then E says video titled "Never Buy This 6 Brand Whey Protein." And then, my lord, F, video titled "7 Worst Protein Powder Brand."
Yes. Worse than you. Worse than your
Poison,
case.
poison, my lord.
Poison is yes.
Now, my lord, if I may show my credibility, my lord, 16.1, my lord, and 16.2.
Oh,
The
right.
defendant number
Oh, you
one.
had you yourself were.
Yes.
Oh, right,
yes,
right, right.
yes,
That acquires different importance.
my lord.
মানে এই apparently ছিল। Yes.
My lord, 16.1 says defendant number one is a certified personal trainer and a sports science nutritionist.
Yes.
My lord, that's my credential. 16.2 with the primary goal. My lord, this is my object. To spread awareness and integrity in the fitness industry.
Were those ASCI or whatever those rules, guidelines considered here?
My lord. There also, my lord,
The rules regarding influencers?
yes. My lord, this I have to check. I have not, my lord, I will be
This is
very
your
candid.
just an introduction to what you are.
My lord, yes, my lord, I,
16.1 is just it states that you are this.
yes.
But
yes,
whether you are qualified to must have been dealt with somewhere.
yes. My lord, and then 16.3, my lord, says that defendant number one is dedicated to the mission of verifying, auditing, reporting on the quality, safety of health products and supplements through stringent laboratory evaluations and aims to be a trustworthy.
These are all headed by case set up by the defendant number one.
My lord, this is my
Rely on
submission.
these.
Very well.
These
Very
are your
very
arguments.
Very well. My lord, now, my lord, if I may show, my lord, paragraph 53. Interim injunction, my lord, this is in case of defamation and disparagement. The courts in India have consistently followed the Bonnert principle as laid down in the judgment of Court of Appeal in Bonnert versus Perryman. My lord, I will not, my lord, reiterate.
Same
Yes, my lord.
text. Also
Bonnert,
Fraser versus events.
this is also considered.
Slap suits. Bloomberg has been quoted at length at para 55. Up to
Yes, my lord.
para 55 we have already read.
Yes, my lord. Now, my lord, if I may show para 56.
56, Kushwant Singh. Yes.
The Bonnert principle was also followed by a division bench of this court in Khushwant Singh versus Maneka Gandhi, wherein it was held that people have a right to hold a particular view and express the same freely in matters of public interest. The court has to balance the two competing interests, that is, of an author to write and publish, and of an individual against invasion of privacy and threat of defamation. However, the aforesaid balancing has to be considered at the stage of claim of damages for defamation and not at the stage of interim injunction. Now, my lord, if I may show paragraph 58. My lord, this is the Greenpeace judgment which has been considered, paragraph 58. In this case, Greenpeace India had created an online game called Turtle versus Tata with the objective to bring to the public's notice the alleged destruction of olive ridley turtles' nesting habitat by construction of a port by the plaintiff. While showing the plaintiff therein as the antagonist, the defendant number 2, Greenpeace, used the name of the plaintiff as well as its logos. Applying the Bonnert principle as followed by the division bench in Khushwant Singh, the court did not grant an interim injunction in favor of the plaintiff. The principles that weighed with the court is not granting the interim injunction in favor of the plaintiff may be summarized below. It would be unreasonable to place restrictions on the freedom of speech and expression before the full trial takes place. Reasonable criticism, comment, and parody is largely protected within the right to free speech under the Constitution. Even if the plaintiff has received the requisite approvals, it would not mean that the concerns raised by the defendants are not genuine or backed by materials. At an interim stage, it cannot be stated that the actions of the defendants are mala fide. Just because internet publication has wider viewership or a degree of permanence, it would not mean that a different standard for grant of injunction in variance with the Bonnet principle would have to be followed. Adopting a different approach would result in disturbing the balance between free speech and interest of the public. The use of hyperbole and exaggerated form of speech or parody would not entitle the plaintiff to grant interim injunction. Now, my lord, in analysis and findings, my lord, paragraph 61, my lord, kindly sees. In the present case, it's an admitted position that the defendant number one is a social media influencer with a huge following on social media platforms such as YouTube and Instagram. The defendant number one claims to be a personal trainer certified from American Council of Exercise and Sports Science nutritionist certified from K11 School of Fitness Science. Defendant number one has filed his certificate issued by the American Council on Exercise along with the written statement. The defendant number one started his YouTube channel all about nutrition in April 2019, and his 2 videos, which are subject matter of the present suit, was posted on the YouTube channel. Now, my lord asked me a very pertinent question. My lord, here also, my lord, para 67, I had the disclaimers, my lord, which was considered. Para 67 was my disclaimer, beginning at the beginning of the video. Further disclaimer, my lord, that was also noted in the next page, Roman 6. And my lord, thereafter, my lord, from para 70 onwards, my lord, defense of truth and justification, that was noted. And my lord, here also, there was lab test reports which I have relied upon. My lord, these lab test reports, my lord, has taken note in the judgment at paragraph 73. Laboratory reports prima facie stage relied upon by the defendant number one cannot be disregarded only on account of the fact that laboratories in question were, my lord, this is now recognized by FSSI. My lord, now, my lord has asked me a very pertinent question as to the influencer, my lord. Yes, my lord, my learned friend has pointed out, my lord, paragraph 86, my lord, kindly sees. My lord, this guideline regarding influencer, ASCI, my lord, that has been noted. Further, as noted above, the impugned videos 1 and 6 do not include any sponsorship or paid promotion of any third-party brand and therefore do not qualify to be advertisement to be covered under the ASCI guidelines. ASCI itself defines an advertisement as paid for communication. Well, this was also in the disclaimer that I have given, that I am not sponsored by anyone. Addressed to the public or a section of it, the purpose of which is to promote directly or indirectly the sale or use of goods and services to whom it is addressed. Any communication which in the normal course may or may not be recognized as advertisement by the general public but is paid for or owned or authorized by the advertiser or their advertising agency would be included in the definition. Now, my lord, 87, my learned friend, my lord has pointed out, in light of the above, the ASCI guidelines would not apply to the defendant number one. In any case, the qualifications of the defendant number one are irrelevant in the present case since he is backing his comments with the test reports issued by accredited laboratories. Then paragraph 89.
Have you annexed a copy of the ASCI reports anywhere? Guidelines?
My
You
learned
annexed.
has.
In the injunction application, you will
Yes,
find
my
it.
lord, it's there. My lord, I will page number. Injunction. My lord, thereafter, my lord, para 89 says, therefore, on a prima facie consideration, the defendant number one has established a bona fide defense of fair comment.
Yes.
So, my lord, the prima facie established by me, that is a bona fide defense of fair comment, my lord, that has been considered at para 89. My lord, similar facts, my lord, and circumstances.
Yes.
Now, my lord, to conclude, my lord, paragraph My lord, 112 and 216, if my lord kindly sees. My lord, in fact, it was treated to be a constructive criticism. It was treated, my lord will find that at paragraph 97. In my considered view, there is nothing wrong in the defendant numbers 2 and 3 relying upon tests conducted by the defendant number 1. Further, the defendant number 2 has clearly stated in his video that he is only giving information with regard to the plaintiff's product and asks the consumers to make their own choice. It is also stated that he expects the plaintiff to work on the plaintiff's product to improve its quality. Therefore, on a prima facie view, the defendant number 2 and 3 are engaging in constructive criticism of the plaintiff's product. Now, my lord, conclude, if my lord kindly sees paragraph 112. In view of the discussion above, the plaintiff has failed to show that the defenses of truth and fair comment put up by the defendants are palpably false and or are bound to fail at the stage of trial. On prima facie view, the plaintiff has also failed to make out a case for disparagement against the defendants, as it cannot be said that the contents of the impugned videos are false or misleading or have been made in a malicious manner with an object to cause damage or injury to the plaintiff. Therefore, applying the Bonnard principle as approved by the judgments of the Honorable Supreme Court as well as this court, plaintiff has failed to make out prima facie case for grant of interim injunction. Lastly,
It was passed in a suit.
this
Contested hearing of the injunction application.
my lord. And lastly, paragraph 116, plaintiff's application for interim injunction was dismissed. Original suit was filed before the High Court. My lord, the ASI, my lord, it's there in their petition. My lord, 181, if my lord kindly, yes, of the supplementary. My lord, I'm grateful to my learned friend, my lord. It's at page 181. Yes. Guidelines for influencer advertising in digital media.
These guidelines have a statutory backing or any sort of backing as per them.
My lord, this I have to, my lord.
They have to.
Miller, this is under the ASCII code. This is under the ASCII code. Miller. There's a statutory code, Miller.
We'll look into that also, Mr. Ghosh, on the next occasion.
Yes, yes, yes. I'm very sorry I couldn't be here, Miller.
No, not
So I joined President.
Ms. Shakut will start with these guidelines on the next occasion.
My lord, my lord. And my lord, I will also show the API, my lord, volume 2.
Get it.
Grateful.
Heard in part for further, release the matter for further hearing on August 18, 2026.
Grateful, deeply obliged. My lord, I am very grateful for the patient hearing.
No question.
It's de novo again because the bench has changed.
Yes.
Because I started on Tata Press.
Yes, we have our markings also.
Yes, yes, absolutely. Extremely well argued by my lord.
ওনার সঙ্গে বসে লাগবেন কেন লাগবেন
My lord, before rising, 39 মানে petitioner evicted করে মানে tomorrow petitioner evicted.
What can you do now? Now you are submitting. Could have mentioned throughout the day. What can you do now? Why didn't you mention at 2 p.m. or 1 p.m. or whatever?
Think মানে matter will be matter will be there. মানে today তাহলে একটু মানে appear
Acha Peril, what is the matter? Let us. 39. Din 39, sir. Is there any caveat in the matter?
no my lord.
দিন 39 ফাইলটা তাড়াতাড়ি দিন মিটিং আছে কত সময় নিলে হবে What is the matter about? Start the matter.
মানে plaintiff filed a eviction suit, my lord. That eviction suit he have not filed any sound.
You are the
that-
defendant.
Yes, my lord.
Eviction suit on the ground of?
Expertise order, they have not served any copy. Expertise order, therefore, we file an application misappeal. That was dismissed.
Eviction was granted on what ground?
What government? They have not served.
What?
No, someone has been served, my lord. Eviction suit was.
Before filing the appeal, you did not take a certified copy of the plaint and the written statement.
No.
Why? You could take certified copies of the plaint and the written statement. How do you know what order was in what sort of suit it was?
Madam,
filed?
kindly say page 17. Page 17, my lord.
Yes.
Page 17, my lord, they filed a execution suit and execution suit we filed order 39, order 9, rule 13 we filed. That was the application. That was my lord dismissed. On the basis, my lord, they have passed order, 1st August, they have.
It's the impugned order. You filed an order 9 rule 13.
Yes.
Eviction suit was filed on what ground?
They
You
have
filed an order 9 rule 13. You must know on what ground you were evicted.
government, they have not served any copy, therefore we do not know.
Eviction was obtained on what ground?
Eviction doctor, my lord, they have filed eviction. We had application copy. We had, my lord, respondent at the matter of the either file an appellant. They have not served the copy. Therefore, expertise order. Against the expertise order, my lord, we filed an application misappeal, my lord. That was dismissed. In the matter execution suit, my lord, we filed order 39 rule 1. My lord, kindly see. Page 11, my lord. Order 13, order 9, rule 13, we have filed an application. That was, my lord, dismissed.
No. This case is under section 47. Not
Mis-
appealable at all. Not order 9 rule 13.
Miscase was dismissed, my lord. Miscase was dismissed.
What have you challenged here?
Challenge, my lord, they have not served the copy any. They have not served any copy. Therefore, we do not. No.
What have you challenged here?
Challenge, my lord, they have without served the copy, my lord, challenge here, my lord. They execution already they have evicted. On this ground, we have challenge here. Today, my lord, they will be evicted 12. এইটাই তো বলি।
Why have you filed a regular first appeal?
Regular first appeal, my lord, they have misappeal already dismissed. Misappeal already dismissed against the, my lord, first appeal.
Misappeal is dismissed against that you have filed a first appeal.
Yes.
Revision lies. Order 9 rule 13.
Order 9 rule 13. Execution case filed, they have to file an order 9 rule 13.
Order 9 rule 13 has been dismissed.
Yes.
Against that what lies? It is appealable. Under which provision is order 9 rule 13 appealable? This is against addition. You filed an order 9 rule 13 that was dismissed.
That was dismissed.
Against that you preferred a misappeal.
Misappeal.
Misappeal is preferred under which provision of law?
Under section 48, my CPC, therefore we file an appeal.
Section 48. What does order 43 speak about? Sorry, we will not take it up. First appeal does not lie at all. Order 43, you have to prefer order 43. If you order 9 rule 13 is an appealable order under order 9 rule 13. Against that, no second appeal lies. The present first appeal has been preferred against an order whereby the appellate court, in a miscellaneous appeal, has affirmed an order passed by the first court dismissing an application under order 9 rule 13 of the Code of Civil Procedure filed by the appellant. Full stop. Next para. However, the appeal is expressly not maintainable in view of no further appeal being provided for against an appeal filed under order 43 of the Code of Civil Procedure comma, read with section 104 of the code. Full stop. Accordingly, FAT 293 of 2026 is dismissed as not maintainable, with liberty to the appellants to file an appropriate challenge against the impugned judgment. Full stop. Liberty is given to the learned advocate on record for the appellants to take back the certified copy of the impugned judgment upon furnishing a photocopy of the same. No, before Madhur's write